Assalamualaikum and good day, Sir Shafiq. My name is Nur Najjat binti Baharudin with Matrics number 051748, and today I will be presenting on the drafting of Royalties and Public Authorities Act 2021, or could also be called as Act 111. First of all, this act was drafted by us to provide new laws for the offences carried out by the royalties and the public authorities of Malaysia. It was also enacted to regulate the moral and etiquette of the royal families and the public authorities on their action, and also to give power for the court to elect the commissioner to pursuant to this act. There are 6 parts specifically in this act, which are the first section preliminary, general explanation, offences and punishment, power of search, seize and arrest, inquiries and remedies. Moving on to the first part of this act, punishment of offences committed within Malaysia, which explain that every party that is subjected under this act shall be liable to punishment under this act, and punishment offences committed beyond but which by law may be tried within Malaysia. Any person liable by law to be tried for an offence committed beyond the limits of Malaysia shall be dealt with according to the provision of this act. And the second part of this act, which is the general explanation, in this part I will be explaining on any term that is mentioned in this act, which is the first of all, royal bloodline. Royal bloodline is a royal descent from a previous or current monarch. Conference of rulers is Majlis Raja-Raja that has been conferred the power to decide on matters of religious matter, occasion or events performed for the benefits of the federation. Public authority is a government servant or legal person performing public administrative function. Transparency is an accountability in any arising matter. They shall be open to the public involving because the matters are involving to the public. And court is a body of judge which is empowered to act judicially. Judges is a person who is officially designated as a federal judge. Wrongful gain is any property that is gained by unlawful means. Dishonesty is anything done with intention of causing wrongful gain or wrongful loss to another person. Remark is as plain as the comment of saying that tainted the sovereignty of Malaysia and the image of Islam as the religion of the Federation as conferred in Federal Constitution. Meanwhile, illegal activities is said to be any activities against the Penal Code. Last but not least, private business is any business owned privately by either the royalties or the public authorities. In part 3 of this act, which is offences and punishment, which is divided into 4 parts. The first one is the offence of the private business. Any party subjected to this act who are found to have wrongful gain by running private business or business when they shall not have any, shall circulate the profit gain to the country and terminate the business immediately. In section 16, which are personal interests, any party subjected to this act who acted against their responsibility for their own personal interests, whereas such act only benefits them, shall be subjected with imprisonment for a term which may extend to 10 months, or with fine not less than 50,000 or both. For example, the change of government that is contrary within the Federal Constitution. In section 17, which is the offences of negative remarks, any party subjected to this act who leave negative remarks either orally or written shall be subjected with public apology and community service up to 720 hours and a fine not less than 100,000 ringgit. For illustration, A said a statement that is misleading and contrary to the belief of Islam in Malaysia. In section 18, in regards to any criminal offences, any party subjected to this act who committed any criminal offences shall be subjected and be punished accordingly to the Penal Code. In part 4 of this act, which are the power of search, seize and arrest, section 19 explains whenever it appears to any RPAC upon information and after such inquiry as hitting necessary that there is a reasonable cause to believe that in any premises there is evidence of the commission of an offence under this act, he may by warrant acquired from the High Court directed to any police officer to enter the premise by force if necessary and there to search for seize and detainment for any evidence. In section 20, obstruction of search, A person shall be guilty of this offense if he assault, obstruct, hinders, or delays any police officer in effecting entrance to any premises under this act, or in the execution of any duty imposed or power conferred by this act, or fails to comply with any lawful demands of a police officer acting in the execution of his duty under this act. In section 21, which is complaint, any person may make a complaint to the RPCA about any conduct as they shall specify in the complaint that has been done or engaged in or issue arise in the public. Meanwhile, in section 22, RPAC shall carry out an investigation raised by the complaint of the public notwithstanding. First, where the public has raised an issue that involved the royal and public authority, RPAC, without any exception, shall carry out an investigation notwithstanding the status of the royals and the authorities. In any such case arise, the provision of this act shall prevail and the decision shall be brought up to the court. In part 5, which is inquiries, in section 23, it explained the appointment of the commissioner. The judges may appoint the commission of RPCA under this act, which stands for Royalties and Public Authorities Commission. The appointment of the commissioner is one way that we can adapt from the Western jurisprudence to resolve matters that involve with the public. In section 24, duties and powers of commission. Commissioner shall inquire and start investigation when it is reasonable, as in when the commissioner deemed fit to do so, and the public has signed a petition to inquire about such act. Commission may carry out investigation of situation when royal and public authorities committed offence in part 3. Situation in which affects the public perception to the royals and the public authorities. In section 25, by means of the conduct of the investigation, before the investigation starts, the commission shall inform the public that the matter is being investigated through press statements, and the commission may, for the purpose of an investigation, take the public opinion of the public into consideration before conducting the investigation, and the complaint shall be done through a formal report. They shall also consider the submission made by the royals and the public authorities, and the result of the investigation shall be exposed to the public once ordered by the court, and any arising issue will be cleared out to maintain the dignity or either prosecute the royals and public authorities. Moving on to the last part of this act, which are the remedies. In section 26, a remedy given to the public which explains the power of the court to order RPCA exposing the outcome of the investigation. It is considered to be one of the remedies as the public deserve to know the outcome of the investigation because they do play a part of the complaint acts done by royals and the public authorities. Meanwhile, in the section 27, if a royal bloodlines are caught with illegal activities, any monetary benefit shall return to state, and if public authorities are caught, the monetary benefits also shall return to the state property, and 50% of their monthly wage shall be deducted accordingly. I guess that's all from me. Thank you.